distressed, and there was a delay about 6 hours before the transfer to a hospital with proper neonatal facilities. So these are the facts of the case. The High Court at first sided with the medical center or the defendants and dismissed the claim by saying that the doctor who delivered was not negligent. And so it said that the baby's medical condition, cerebral palsy, and other disabilities was not caused, there was no proven cause or that is related to her birth conditions. So because the doctor who delivered was found to be not liable, there's naturally the medical center and the PIC too were held to be not liable. But then this was not the end of the story, because the case then was brought by the plaintiff to the Court of Appeal. And in the Court of Appeal, the Court of Appeal did not hold the doctor liable. It said that the doctor did not breach her duty of care in delivering the baby, because there was no misdiagnosis, okay, and she not in or the manner in which the delivery was conducted. However, the hospital and the PIC were held liable, because the Court of Appeal said that the PIC and the medical center owed a direct duty of care to patients, and this includes ensuring adequate facilities and timely access to specialists. So the court found independent negligence by the first and second defendant, which is the medical center and PIC, and held that they had failed to provide a pediatrician at the time of delivery, failed to ensure timely neonatal care, and unacceptable delay in transferring the baby to a proper facility. So these were systemic and administrative failures and not clinical ones, but nevertheless, it made the PIC liable. And the court further said that the High Court was wrong in its initial conclusion that there was no causation, and that the High Court also had rejected expert medical evidence. The Court of Appeal found this to be flaws in the High Court's judgment, hence overturning the High Court's judgment. So as of today, the judgment of Court of Appeal is still good case law. And what is the takeaway from this Nur Fuziatun's case? In summary, PIC can be liable even without direct patient interaction. And the liability of PIC arises from operational deficiencies, system failures, and poor management of whatever authority or powers within the PIC's remit. So the focus here is not on individual treatment, but system accountability. At the same time, I would like to share with you that this case is presently pending appeal in the federal court, and we have to wait for the outcome of the federal court to see whether the federal court will uphold the Court of Appeal's judgment that holds the PIC liable, or reverse or revert to the High Court judgment to find that the PIC and medical center is not liable. So that is where we are. So what does this mean in reality? There is an expanded risk exposure. PIC is personally accountable for clinic systems and its ultimate authority and accountable. Is a holder of accountability for patient safety, clinical quality, staff conduct, and overall clinic operations. So if there are issues with any one of this, then that will be the liability of the PIC. So if we look at the roles and responsibilities of a PIC, number one, clinical governance and patient safety. So these are the factors here: ensure all medical services meet accepted clinical standards, supervise doctors, nurses, and allied health staff, monitor quality of care and handle clinical audits, ensure proper diagnosis, treatment, advice, and follow-up practices, manage complaints and incident reporting, including grievance mechanism, ensure informed consent is taken. And regulatory compliance of PIC will be as number one, ensures the clinic complies with licensing requirements. Number two, maintain valid registrations, permits, and certifications. Number three, adhere to guidelines by the authorities. Number 4, ensure proper documentation and record keeping. So this is regulatory compliance. Third, staff management and supervision. Okay. Basically, here is where the PIC has to oversee hiring and training of staff, ensure staff are licensed and practicing within their scope, especially locum doctors, promote continuous professional development. Okay. And when we come to the person in charge, like, okay, there is a gray area, I would admit, that when we look at the Act, the PIC is also the licensee, especially in smaller setup, where the licensee and the PIC are different people. Then the question will be, to what extent is the PIC responsible? Because Section 31, subsection 1C of the Act requires the licensee to ensure that all persons employed or engaged by the facility are registered under any law regulating their registration, or in the absence of a registration law, hold such qualifications and experience as are recognized by the DG of Health. So this obligation is ongoing and not merely a one-time check at the point of hiring. So it becomes a responsibility of the licensee or the PIC, as the case may be, to ensure that annual practicing certificates are kept valid for all registered professionals throughout employment. Lapses in APC expose both the PIC and the licensee to criminal liability under the Act. What is the practical implication of this provision in Section 31, subsection 1 is that the reference to persons employed or engaged is deliberately broad. It captures not only permanent employees, but also contract staff, part-timers, and outsourced personnel in the clinic or the private healthcare facility. Outsourcing a function does not extinguish the PIC's statutory duty to verify qualifications. So here is where the PIC has to make sure that HR systems are built to flag expiring registrations proactively, because failure to adhere to these regulations or requirements becomes a criminal offense as well as a fine. They exposes the PIC to a fine. And this is specifically, or more specifically, for locum doctors, legal status and PIC liability. In private clinics, where there's frequent engagement of locum doctors on ad hoc or sessional basis, there's also a question of whether are they employees or independent contractors. Because if you look at the Act says to the licensee or the PIC, or both, may be liable for those who are employed. So are people, locum doctors, employees, or are they independent contractors is a question of law. So court will examine if this is ever disputed. The examination will center around the degree of control, how integrated or how integral are they to the business or the facilities operation, economic dependence, and exclusivity. So, for instance, a locum engaged regularly and supervised closely may be reclassified as an employee, triggering Full Employment Act 1955 and EPF or SOCSO obligations, as well as the obligations under the Act as for PIC's requirements. So, PIC liability here does not depend on classification. Regardless of whatever the classification is, there is an obligation. So what this means in reality is, besides the Act, whatever offenses and penalties, what the PIC faces is stiff penalties. The fine can be up to 100,000 and or imprisonment. But there is also other jeopardy under the Malaysian Medical Council disciplinary jurisdiction. There is a corporate liability as well, because there is an issue of whether the PIC will then be liable for exposure that is beyond just medical. There can be criminal liability too. The thing that I would like to stress this evening to you is the liability for employment and hiring and firing is also or may also be the PIC's responsibility, the way the Act and the sections, the relevant sections that I showed to you just now are structured. So for instance, if you see what do PICs, have to take care or take charge of, they have to take charge of administration and operations, and they have to take care of clinic operations, main service efficiency, billing, confidentiality, data protection, and they have to also play the role or wear the hat or cap of an employer. So they are the clinical regulators and employers at the same time. Because every private healthcare facility is also a workplace, and the PIC typically sits at its apex as either the employer or the person who exercises the employer's authority. Meaning you are the person who will be interfacing with the staff in the clinic and the healthcare personnel, and therefore you become vicariously liable as an employer. So two distinct legal regimes that you need to be concerned about here is one is the Private Healthcare Facilities Services Act 1998. That's about how the facility is run and how healthcare is delivered to patients. And employment law is how the people who deliver the healthcare are treated by the healthcare facility. Now, why does this matter? Because besides whatever that is provided, the liabilities, responsibilities that is provided in the Act itself as a PIC, you also happen to become liable independently if there is a wrongful dismissal claim or a violation of statutory benefit. For example, non-payment of EPF or SOCSO, for example, or if there is a complaint of harassment, discrimination against anyone working in the clinic or against any other responsible person or peers working, colleagues within the setup, then the PIC will be one of the people who are answerable or liable. So patient safety, wrongful dismissal, issues, fraud, criminal issues, whistleblowing, all these will also visit the PIC, and the PIC cannot say that they do not know, they have no responsibility for such things, that they only take care of clinical matters, because under the Act, you are responsible for both operational as well as management of the healthcare facility. This also brings to me to an interesting observation that it's a requirement for all practitioners, doctors in private healthcare facility to have professional indemnity insurance. So for instance, if you're hiring locum from, say, government sector, and the government sector locum practitioner or the doctor from government service does not have a professional indemnity insurance, then it becomes the liability of the PIC to an extent as well. For rest of the presentation, I'm going to focus on the employment relationship to give you a coverage of what is expected from the employment aspect. So a few things, core matters to discuss is what is an employment relationship. An employment relationship is fundamentally contractual in nature. So it's very much dependent on the terms and conditions that are stated in the contract of employment that is given to any of the employees, whether they are medical or allied professionals. The agreement is subject to the Employment Act 1955. There is another important act, is the Industrial Relations Act 1967. The Employment Act 1955 forms the basic minimum standards of employment in Malaysia. It applies to everyone, regardless of your pay structure, whether you are highly paid or you are a manual worker, non-manual worker, whoever is an employee who has a contract of service, then the Employment Act 1955 provides coverage and protects these people. And therefore, the minimum requirements of the Employment Act 1955 must be followed, must be complied with. What if you don't comply with that, these minimum terms and conditions, then the PIC and the clinic, the licensee, are exposed to a complaint to Jabatan Tenaga Kerja or Labour Department, whereby there can be a summons and there can be a decision made against the responsible person or persons, and these summons or decisions, if they are ignored, it can lead to a fine and even prosecution. Another important act is Industrial Relations Act 1967. It is specifically relevant to consider that this is one law that enables any one person who feels that they have been unjustly terminated. So they must lose employment, and they feel the loss of employment is done in an unjust manner by the employer. They can file a case in the Industrial Relations Department first or Jabatan Perhubungan Perusahaan within 60 days of the termination or loss of employment. Following which, there will be a meeting attendance, a mandatory meeting will be called for both parties, meaning the employer, it could be the PIC, it could be the licensee, it could be both. They have to attend a conciliation meeting to discuss how to reconcile with the employee or the workman who has lost his or her job. And if there is no conciliation or the conciliation efforts are unsuccessful, then the matter will be referred to the industrial court, and the industrial court will then invite parties to present evidence, and based on the evidence, it will decide and determine whether the accusation or allegation of unlawful dismissal or unjust dismissal is true or untrue. If it is found to be true, then the employer will be liable for payment of back wages and compensation in lieu of reinstatement. If you are following social media platforms, especially news platforms like Free Malaysia Today, you will find such cases are often reported with screaming headlines saying that employee wins a few 100,000, sometimes more, even at times it's R1 million or more against the ex-employer. The other law that is relevant to be considered that you have to make sure you follow is minimum wages. We have minimum wages orders, and this is based on the Minimum Wages Act of 2012. Every 2 years, the minimum wages orders are renewed with new mandate. So currently, the prevailing minimum wages is RM 1,700 ringgit per month. So it means that you cannot hire anyone for a salary which is less than 1,700 ringgit per month, right? This is set to change. In this year, probably there will be a fresh mandate for increasing the minimum wages, and potentially from next year, the 1,700 ringgit could even increase to a higher sum. But at this point in time, it is still 1,700 ringgit per month. Another law that is specific is employees' provident fund contributions. These must be followed. Regulations are very strict on EPF contributions. There must be deductions made from the employee's salary, and together with the employer's contribution, these monies must be remitted to the EPF fund on a monthly basis. Social Security Organization, SOCSO, is a similar requirement, social benefit legislation. So the employee's portion must be deducted, employer's portion of contribution must be topped up, and both must be remitted. Similarly, Employment Insurance System, EIS, is also another deductible that has to be remitted. So all these are to be ensured. So the requirements to comply with all these Okay, if you ask me who has to, of course, the employer has to. But if the PIC stands in the shoes of the employer, then the responsibility is also shared by the PIC. Especially if you find that there are cases where the employer does not engage with the workman or the employees directly, but it is the PIC who's doing all the administrative work, and relationship with the employees are maintained by the PIC, there's every likelihood that the PIC will be dragged into a dispute if there is a dispute. And if we look at terms and contract of employment, just to give you some overview, okay, contracts cannot waive the statutory minimum, and if there are ambiguities, it will be interpreted against the employer. A sample of it will be, let's say the contract says no overtime is payable for work beyond normal working hours. This will be invalid because the provisions of the Act will override, especially where the employee earns less than RM 4,000 ringgit per month or is engaged in manual labor. For those who are earning more than RM 4,000 a month, you could say that I have a contract that does not pay overtime. It is not illegal, but for those who are earning 4,000 ringgit per month or less, or those who are engaged in manual labor, you have to provide overtime. Okay, you have to pay them for overtime work. And at the same time, if, for example, if you pay someone more than 4,000 ringgit, and have been giving them overtime, then those are better terms and conditions. And the law says that if you have agreed to give better terms and conditions and the statutory minimum, those are binding on the employer too. Okay. Another example will be payment of wages. According to this Employment Act, an employer must pay not later than 7th of the following month. Okay, so wage period, every wage period, if it's a monthly salary, you have to pay by the 7th of the following month. Can an employer make deductions from employees' wages? Generally, deductions are unlawful, except if the deductions follow into specific provisions that are already made legal by the law. One is deductions to the extent of overpayment of wages. So if you have overpaid the salary of an employee, you can deduct that overpayment because it's a payment made by mistake. But that too is subject to specific conditions that has to be fulfilled. Or deductions for the indemnity due to the employer by the employee. An example of that will be if the employee leaves without serving proper notice. So when you have the last month's salary to pay to the employee, you can account for the shortfall of the notice or the fact that no notice was given, because that is an indemnity that is due to you as the employer. There, in that circumstances or that situation, you can actually make a deduction. Or if you have made lawful advances to the employee, you can recover the advance from the wages, or deductions authorized by any other written law. And such examples of such deductions will be EPF, SOCSO, EIS, and similar law where there is deductions to be made, then you follow that, then that's lawful. Apart from these specific examples, you have to pay the salary, agreed salary in full to the employee. And if there is no payment according to the contract, the employee can always walk to the nearest JTK and file a complaint against the employer. And now there is also a prohibition to make payments in cash form or in the form of check to the employee, except through an account open in a financial institution. If you want to pay someone via check, for example, or give cash, you have to go to the JTK and ask for specific approval to do this. If the DG of Labor says, yes, you are allowed to make payment in cash form, that's fine. But if not, you have to make payments via bank transfer only. What about working hours? If you look at the law now, it says that every week you have to give one full rest day to the employee. And exception to that will be if the work has to be carried on a continuous basis or if it is a shift working system. Overall, the limits are these. If someone works continuously for 5 hours, you have to give a minimum break of 30 minutes. Minimum, the break can be longer. If there is employment, it has to be maximum 8 hours in one day, except shift workers. Shift workers, there's a little flexibility there, but normal work hours, that is non-shift hours, has to be maximum 8 hours. And if there are breaks, let's say you close the clinic in between, maybe in the mid of the day, lunch hour, the clinic is closed, the spread in one day, the maximum spread has to be 10 hours. It cannot be more. And 45 hours is the maximum allowed in 1 week. So if an employee exceeds 45 hours in general, except again, there is a provision, some flexibility for shift workers, there is overtime. And if there's no overtime, you cannot force an employee who's not subject to overtime pay to work more than 45 hours per week. What are the mandatory benefits under the Employment Act 1955? Annual leave is mandated, minimum 8 days, maximum 16 days per the Act. And it depends on whether the employee has served less than 2 years, 2 to 5 years, or more than 5 years. Public holidays is also mandated by the Act. 11 public holidays are stipulated in the Act. 11 of which 5 are mandatory days. The 5 mandatory days will include National Day, Labor Day, which just passed, okay, and the state ruler's birthday, and also the Yang di-Pertuan Agong's birthday. Sick leave and hospitalization leave for those who have worked for less than 2 years, 14 days of sick leave. And those who have worked for 2 to 5 years, 18 days, and those who have worked more than 5 years, 22 days of sick leave is mandatory. Hospitalization leave will be an additional 60 days provided per calendar year. So one of the questions that I often come across is this: what if the employee is a probationer or someone who has just joined the practice? They have not worked for 1 whole year, they've just come on board. And they have barely been on the job for, say, 2 weeks or 3 weeks, and they meet an accident or they have a medical problem that requires them to go on hospitalization leave or sick leave. The question is, can we prorate the leave based on the time that they have actually served? The answer is no. This leave that is provided as mandatory leave, okay, in the Act is for calendar year. So even if the employee has only served you for 2 weeks and he meets an accident and or some other medical issues, he has got appendicitis or some operation that requires him to be on full medical leave, you have to provide the leave as per the Act, regardless of how long the employee has been in service. Maternity leave, 98 days, but maternity leave has some preconditions, okay? So it's not like someone who can join you and immediately within 1 month or 2 months can claim maternity leave. There are preconditions to fulfill. Paternity leave is provided, 7 days of paternity leave now under the Act. And of course, as I said, EPF savings, employees' deductions from the salary of the employee is 11%, and employers' deduct contribution to top up to the 11% will be either 12 or 13%, depending on the salary level of the employee. Okay. The key issues is, if you look at medical leave, for example, the medical leave, as you are very well aware as doctors yourself, okay, it's only valid if it is certified by a registered medical practitioner or a medical officer. And can a healthcare employer demand that his staff must only use his own sick leave certification. That means do not permit, medical leave from or sick leave given or obtained from another facility or healthcare doctor. The answer is no. You cannot insist in that manner. Okay. If you have evidence that an employee is bluffing and that is a misconduct, you can take action, but you have to investigate and prove that the employee was in fact feigning the illness or is malingering. So if there is a medical certificate, it's a prima facie presumption that the person is genuinely ill. And if you want to rebut this, it has to be done with clear evidence, not mere suspicion. Some of my past experiences in such cases has been when the employer contacts the medical facility or the healthcare provider, then it comes to light that there is no record of visitation by this particular employee. So then it begs the question, how did the employee even obtain the medical certificate? So there was one particular case of a bank staff that I had represented the bank in. It turned out to be that the employee has bought, the medical certificate from the receptionist, and the doctor did not know. So there was no visitation, no record in the medical card of the particular employee. So when the doctor was called by the bank to investigate what is the problem with this employee and why is he on medical leave, and the doctor said, we checked, I don't have record of seeing him. He's not my patient. He did not come and see me. So that led to actually dismissal of two people. The doctor had to dismiss his nurse, and also the bank had to dismiss its staff. So basically, but there was proof there was proof, and we could bring the doctor to testify in the court case when the employee challenged it later on. And Section 20, moving on to the Industrial Relations Act, this will kick in when there is a person. The Act uses the terminology workman, but a workman is anyone. It can be a woman or a man who feels he or she has lost a job because they have been unfairly or unjustly dismissed. Then they can file a claim, as I said before, provided the claim is filed within 60 days of the dismissal. And then it will go to conciliation stage at the Industrial Relations Department and might end up in the industrial court if parties can't see eye to eye and resolve it at this stage. Right? I'm not sure how many of you had the misfortune of having to defend your decisions in industrial court. It can be a painful process. So best thing is to avoid being placed in such position. Another provision that we have now in the Act, is anti-discrimination. Anti-discrimination is any kind of discrimination based on gender, religion, race, disability, or other characteristics. And this kind of discrimination can be against recruitment, terms, promotion, training, and termination. And an employee who believes that he or she has been discriminated against by the employer may lodge a complaint with the Director General of Labour. Then the DG will inquire into the complaint and call the employer and direct the employer to take corrective actions. So how is this relevant? Because in healthcare, for healthcare employers, clinics and hospitals, I would recommend that you review your recruitment practices, termination decisions, promotion policies, etc., to ensure that these are not based on any of the characteristics that I described just now. Particular care is needed in cases involving employees who are pregnant, who have a disability, or are on extended medical leave. All three are common grounds for discrimination complaints and can also lead to claim of unjust dismissal against the employer. So if in a summary, you ask me what are the employer's key responsibilities, I will say these four are the key responsibilities: pay wages on time, follow employment laws, comply with statutory obligations on annual leave, sick leave, maternity leave, whatever that is provided for in the Employment Act. Provide safe workplace and environment, because under the Occupation Safety Health Act of 1994, OSHA also applies to private healthcare facilities. So there is a legal requirement to ensure workplace safety, provide training, protective equipment, and minimize risks wherever possible. If there is a breach, then the PIC as well as the licensee will be exposed as employers, because here you wear the hat of employers, and OSHA extends to all employers and it requires mandates that employers provide a safe place of work. And finally, I would say avoid discrimination. Treat all employees fairly to ensure equal treatment to all. How about disciplinary actions and terminations? So far, you have only heard of your obligations and liabilities. Okay. Does that mean that you can have no rights? If you are wondering, my answer is no, you do have rights, but your rights are circumspect or limited to an extent. The right to hire is fully yours. The right to fire is, you have to be really very cautious about that, because it brings on other liabilities. Why do I say that? Because if you look at the overall scheme, we have got, okay, two provisions in the Employment Act 1955. One is that Section 12 of the Act says that notice period is the same for both employer and employee, and it is mandated per the Act when there is redundancy. So, for instance, the notice period in the Employment Act is more than what in the contract may stipulate as a norm. Because typically when I come across contracts, usually I see 1 month to 3 months as the notice period. The Employment Act in general provides 1 month, okay, in cases of employees who have worked for less than 2 years. Where employees have worked for more than 2 years and under 5 years, then the notice period increases to 6 weeks. And if an employee crosses the threshold of 5 years of service, then the notice period becomes 8 weeks. So there could be a gap or mismatch between your actual contract of employment and what Section 12 says. But however, to give you some comfort, Section 12 doesn't override the notice period in the individual employment contract, except when there is a closure of the business or the employee is let go due to retrenchment or redundancy. Only then Section 12 kicks in. Apart from that, you can be assured or comforted by the knowledge that the individual contract that you have issued to the employee will still be valid. Section 14 is another section that you need to be concerned about. It says that if you want to mete out any kind of disciplinary punishment to an employee, be it demotion, be it a warning letter, be it suspension without pay, withdrawal of increment, or the ultimate capital punishment or dismissal, you have to hold a due inquiry before doing so. What is a due inquiry? A due inquiry means the employee must be informed what is the allegation of misconduct. Employee must be given an opportunity to turn up in person and answer the allegation. Only if the allegation, the explanation to the allegation is found to be unsatisfactory, then you can proceed to take any disciplinary action. Failing which, then the employer may fail, okay, or would be seen as not fulfilling Section 14, which is in itself is a wrongful action on the part of the employer. On top of it, then if the employee complains, then the JTK may reverse your decision and hold that the punishment you have meted out is unlawful. So then you have to take back the employee, okay, and restore the employee to the previous position. It's something that no employer likes to do or would want to do. So you have to be cautious in taking disciplinary action against the employees without fulfilling this due inquiry requirement. Okay, I think I've covered Section 20 before. This is the section that provides an employee the ability to go and complain that his loss of employment was without just cause or excuse. Okay. So in other words, sometimes employers do ask me this question: can we not just rely on the termination clause in the contract of employment and fulfill the notice, give the 1 month salary in the hands of the employee and say, thank you very much, you have served me, I do not need your services anymore? Okay, the answer is no. You can't do that, because that in Malaysian context is called termination simpliciter, and we have enough case law to say that if you let go people relying on notice or payment in lieu of notice, that is unjust dismissal. You have to have a proper reason. The proper reason can be plenty. I'll show you in the slide after this what are the reasons that you can rely on to let people go. But if you did that merely because the contract allowed you or enabled you, then you will be held to have acted in wrongful manner and brings on more liability than you might be prepared for. When can termination occur in employment? In two situations: direct termination or indirect termination. Direct termination can occur when you have taken on someone as a probationer. So a probationer is someone who's on trial to fulfill, or to prove his or her suitability. If you find them unsuitable, then subject to certain conditions, which I'll discuss, I'll explain after this, you can let go you can terminate a probationer. We don't say termination. In case of probationers, we use the terminology non-confirmation. So you need not confirm a probationer's tenure, and the non-confirmation will result in termination of employment. Another is fixed term contract of employment, where you take on someone for a specific period. There is a start date, there is an end date, and when the contract date ends, then the person no longer has a job. So that's also lawful. Retirement, currently minimum age of retirement is 60. Poor performance is when the employee is not performing to the standard or expected requirements of the job, or is not producing enough, or poor quality work is produced. Misconduct, as the word itself suggests. Retrenchment, when you're closing down a section of the practice or the entire practice, or you have done maybe innovations, automation that requires lesser number of people, that could result in retrenchment. Another is where is a doctrine of frustration or force majeure, depending on the situation. I'll explain that further. Indirect dismissal will be situations where employer did not dismiss, but employee walks out and claims that he or she has been dismissed. How can that happen? I'll give you an example. For example, the employer did not pay wages. The employee waited. After the 7th of the following month, the wages were not paid. Employee was patient, waited for maybe another week or 2 weeks, and kept asking the employer, when will I be paid? Employer does not give an answer. Perhaps the employer is going through a financial crisis. We do not know. But the result is there is a breach of employment contract already. So the employee in that situation is not expected in law to continue working without protests and without objecting. So the employee can claim that he or she had been constructively dismissed, meaning that the employer's conduct is the dismissal here. Another example of indirect dismissal would be forced resignation. Forcing someone either expressly or impliedly to resign, and the resignation is brought about not by willingness but involuntarily. That is forced resignation. That is also indirect dismissal in a Malaysian law. The other category will be mutual separation scheme that goes wrong. Mutual separation scheme is often used by employers who discuss with the employee, seeking the employee's consent to end the relationship of employer and employee, offering some sort of compensation for securing the employee's consent. For example, let's say you have a nurse in your clinic who has worked, say, for 20 years. And at some point, you feel that, perhaps it might be best if both the clinic, the employer and the nurse separated. So you call the nurse in and discuss and tell the nurse, okay, you have worked for me for so many years. I would like you to leave voluntarily. I will offer you this much of money. The employee says, let me think about it. And after a day, he or she comes back, for example, and says, what if I say no? Then as an employer, you say, if you say no, I will still not keep you on board. So then the employee signs and accepts the money. Does that mean that the employee has no recourse after that, just because he or she accepted the money to leave? The answer is no. In Malaysia, quite often employees take employers' money like that, and yet they walk to the court and file a claim of indirect dismissal. And many a times the employer gets bitten twice. The first round, they paid the employee, hoping to secure the employee's consent. Second round, they pay after the court makes an order in favor of the employee. So there's a double jeopardy there. That's what I meant when I said mutual separation scheme that goes wrong. Now, let's just look at quickly each one of these categories. So for probationers can be terminated by way of non-confirmation. But remember, it must not be arbitrary. When I say non-arbitrary, it means the evaluation of the probationer must be carried out. The evaluation must be a fair one, and the evaluation must objectively determine that the employee is not a good fit for the position he or she holds. So if you take someone, say, on a 3 months probation, in the entire 3 months, the employee is not informed how he or she is not matching up to your expectation. You just let them carry on silently. Comes the 3rd month, end of 3rd month, you serve a letter of non-confirmation. Surely you have the right not to confirm an employee. No one can force you to confirm someone. But if the employee goes and files a case under Section 20, which quite often employees do, the employee is going to accuse you of not giving them a fair feedback and not telling them that they are not good enough for confirmation. Because the employee will say, I was given the impression I was good. The employer never told me. In fact, the employer often took me out on lunches and told me that I'm doing well. So how do you disapprove that? Hence, it's important that you touch base with the employee, be honest in your evaluation, and do tell the employee that if you're not backing up, this is why I'm not satisfied. And I would even go as far as to say that best these things are done in writing, because verbal communication, especially in small setups, may seem like very convenient and the best mode of communication. But when it comes to proving or disapproving something, it's very difficult to establish what happened based on verbal communication alone. So it is good if you had given some kind of letter in writing or a memo or an email, minimum an email to the employee to say in which respect the employee has not matched up to the expectation. That will justify and pave the way for you to not confirm the employee at the end of the probationary period. Okay. Next category, fixed term contract. These are employment contracts that are typically used when the position is temporary or project-based or even seasonal. But the problem with fixed-term employment contracts is, let me tell you, is this, that if you keep renewing someone who's on a short-term duration, maybe it's a 6 months contract, renewed thrice or 4 times, or 1 year contract, but renewed for 10 years, these kind of contracts are deemed as permanent by the courts. So if it is in reality a permanent contract that is dressed up as fixed term, the court will strike it down and will assert that it is not a fixed term. So a genuine fixed term can be for a real short period of time, maybe while you are deciding something, or because you genuinely needed that person only for a short period of time. Let's say a staff that you have taken in on a temporary basis to cover an employee who has gone on maternity leave or extended leave, and it may be 9 months or 1 year. But if you keep renewing someone year in, year out, more likely than not, the court is going to consider this as a permanent employment contract. Okay. Retirement is not difficult. It's one of the most straightforward ways to terminate an employee. But be careful. Oftentimes, I find that employers do keep people even after they attain the age of 60, especially if they are dependable, loyal, long-term serving staff. So what happens if you keep employees after they become 60 years old? The law doesn't say you must retire people at 60. What the law says is the minimum age of retirement is 60, which means you must not retire anyone before they attain the age of 60. But if someone works for you after they attain the age of retirement, it may be for a short duration, it may be on annual contract. But if you, again, as I said earlier, for fixed term employment contract, if you keep renewing the contract year in, year out, the employee can then argue that they can work for life, or as long as they are in good health, they can continue to work. It will be hard for you then to retire someone who has turned 70 or 75. You may have to keep the employee. So there's something to consider as you deal with post-retirement employment. How about, okay, poor performance deals with unsatisfactory work performance. This will be when you hire someone based on their qualification or their representations, and they may hold out to say that they have certain capabilities or competencies, but after you hire them, you find that actually they fall short. Okay. Therefore, you are required to inform the employee or warn them in writing about their performance and their shortcomings. And after warning the employee, you have to give such an employee enough time to improve. And if the employee, despite the warning and the opportunity to improve, still shows up the same failings or the same problems keep cropping up, then you can terminate the employee on the basis of poor performance. Okay. The law does allow employer to terminate for poor performance. The key to winning a case on poor performance, if you're challenged, is, okay, you have to have paper trail. The documentation and evidence in writing is very important. It's not enough if you just said, oh, I have warned the employee 15 times, but where is the evidence of warning? Hardly anything. Then it becomes a problem, okay, for the employer to prove or establish the reason for termination was actually a just reason and not unjust one, as the employee alleges against the employer. Misconduct is when employee is in breach of the employment contract by doing something they are not supposed to do or failing to do what they are required to do. So it can be misconduct can be due to commission or omission, depending on what the requirement is. So SOPs are not met, that is omission, okay? Or doing, okay, a reckless or misbehaving, a reckless act or misbehaving, that can be a commission. So in both cases, the employer must provide due inquiry. So a show cause letter is preferable. Issue a show cause letter, ask the employee to explain why they behaved in a certain manner or failed to do something that they are required to do. Give them time, reasonable time to reply the show cause, and based on the explanation, you decide, okay, whether to hold a face-to-face, interview with the employee by a panel, or hold a proper domestic inquiry. In either case, a due inquiry requirement under Section 14 must be fulfilled if you wish to take disciplinary action against that employee. And retrenchment, as explained earlier, this is when you don't need the services of the employee. So it could be because you are merging two clinics into one clinic, or because you're shutting down, maybe you ran the clinic 24 hours and now you want to reduce the operational hours, or you're shifting the location from location A to a faraway location. These are examples of how people's jobs can be lost due to redundancy, and resultant of or consequence of redundancy is retrenchment. If you want to retrench employees, you can, but you have to give early warning notice to the employee. You must select the employee based on LIFO principle, meaning if you have 2 nurses and you decide you only need 1 nurse going forward, or 1 receptionist instead of 2 receptionists, you have to choose the last in person to be the first one out. You can't choose who you like, but you have to follow the LIFO principle, because the selection process must be fair and must be objective. You can depart from LIFO in exceptional situations, but it requires the employer to provide some other objective criteria or qualification or test, which generally is difficult to prove. So safe to stick to LIFO if you ask me. And then on top of it all, the employer must still give compensation. So compensation will depend on the Employment Act. Employment Act says that if someone has worked for you for less than 2 years, you have to pay 10 days of the salary of the employee for every year of service. And this increases to 15 days for those who have worked for 2 to 5 years. And if anyone has worked more than 5 years, then you have to pay them 20 days of the last drawn salary for each year of service. So you have to give early notice, warning. Second, you have to make sure that selection of employees are fair or is fair and objective. And third, you have to pay retrenchment benefits. Okay, these are the requirements. And there is an additional requirement under the Employment Act is that before any retrenchment is carried out, even for 1 employee, you have to file a form called PK form with the Labor Department. So the Labor Department has to be notified at least 1 month before the employee's termination about this impending retrenchment of employees. It is a notification, but if you don't notify, the employer is exposed to fine by the relevant authority. And finally, doctrine of frustration. Doctrine of frustration is that when something extraordinary and unforeseeable happens, and this disables either party from performing the contract, then the contract dissolves by itself. So it's not a breach of contract, but it's a dissolution of the contract. We call in contract law, it's called frustration. And this can happen due to various reasons. Sometimes it's act of God. It can be a landslide, a fire, or the employee falls so ill that the employee cannot perform his or her duties. So when such an event, unforeseeable event happens, it releases both parties from liability, and there is no basis to sue one another. Nowadays, quite a few times the court has said that when an employee is medically ill or on prolonged illness for such a long period of time, it can be a frustrating event. Okay? But that's actually quite iffy, because in a number of cases too, when employers let go people because they are really ill, the courts also hold that the employer acted prematurely or too fast, or did not give the employee a chance for recovery, and so on. So it's a little, it's a thin ice basically for using medical grounds for as doctrine of frustration. Okay, so constructive dismissal. Okay, in a private healthcare facility scenario for PIC and for doctors generally, Common examples will be unilateral demotion of a senior nurse or medical officer without justification, sudden and unexplained removal of clinical responsibilities or operating privileges, harassment, bullying, okay, especially when complaints were made and these are not investigated, or any form of unilateral reduction in salary or benefits without prior agreement of the employee. This can be examples that could lead to claim of constructive dismissal against the employer. Okay. Forced resignation, as the name suggests, okay, is a situation where undue pressure is applied on an employee. It could be threats, it could be coercion, and the employee feels that he or she was given an ultimatum to resign, or else, and the employee says, I was intimidated and I acted out of the intimidation, I resigned, but I actually did not want to leave my job. And so that person seeks redress from the authorities via JTK, via industrial court. And if it's shown that the employee did act involuntarily and the resignation was caused by undue pressure, then the court will side with the employee, and that will mean that the employer will wind up paying compensation. Okay, so these are the various reasons or causes for which employment termination can be brought about legally. So I believe, okay, I have covered what I've set out to touch upon this evening. And in closing, I'll say this, that if you are embarking on termination of employment, look at it from 2 points of view or 2 perspectives. One is substantively, it must be fair. That means the reason for dismissal must be weighed out. It must be genuine, it must be supported by evidence, and procedurally, you have to follow all the processes and procedures. So for retrenchment, the process and procedure differ from probationary employee. And it differs for someone who's we consider to be a poor performer, for instance. So you have to make sure these are fulfilled. And if you are fulfilled, if you are able to fulfill these requirements, then you are on safe ground. Okay. So action points. What are the key action points for PICs and clinic owners or licensees? Do a staff registration audit, verify that all staff, be it permanent, contract or locum, hold valid registration with the relevant professional body and a current APC. Build a system to track expiry dates proactively. Contract compliance review. Pull out all the employment contracts, review them against the Employment Act 1955. C, make sure there are no gaps, and correct overtime thresholds, sick leave entitlements, public holidays, rest days, annual leave, anti-discrimination, along with sexual harassment provisions. Where you are lacking or you feel there is a lack, correct them, okay? Documentation discipline, document all employment decisions, especially performance warnings, disciplinary outcomes, and separation agreements with clear objective reasons. Okay. Lawful exits only. If you want to carry out workforce reduction, do so, okay, properly. Like I said, follow the substantive as well as procedural, okay, requirements and processes. And clinical governance audit, post that decision that I discussed just now, Nur Faziatun's case, until it is overturned, any system failure will visit on the PIC. It will attract personal liability. So PICs should conduct a governance audit of their clinical systems, referral protocols, specialist access, neonatal emergency coverage, and transfer arrangements. And policy update is also important. Update the clinic's employment and HR policies to reflect the current laws, because sometimes you open the business or the facility many years ago, and in the busyness of practice, you may not have had the chance to relook at many things, and it might be timely to revisit and get proper professional advice and support in making sure these things are, the gaps are closed and these things are reviewed on a regular basis. Okay, so that's all I have in terms of presentation. Happy to take questions if there are questions that you'd like to ask me. And if you think I've worked hard enough, you can let me go back home.
Thank you very much for the very insightful session on the responsibilities of doctors in junior doctors in practice. Ms. Rajesh, so we have 9 questions pending from our audience here. And before I read their questions out, I would like to ask my question. So this is a situation where I have experienced myself, and I've also had many junior doctors come to me to ask this question. So here's the scenario. So when many junior doctors join private practice and when they are on their probation period, most of them are informed by their employers that they will not be entitled for any EPF and SOCSO until they have been confirmed. But upon confirmation, the EPF and SOCSO were not reimbursed for them. So could you please give your advice and comment on this? Thank you.
Okay, that's illegal. Okay. EPF, SOCSO, EIS, annual leave, public holidays, sick leave, hospitalization leave starts from the moment you say the word go. You cannot hold back or you cannot postpone these. Okay, these are rights, they are not privileges. So privileges, you can decide, okay, I will not extend you this privilege now, I will give it to you later. But rights are rights. They start from the commencement of the employment relationship. So if the employer, okay, or the licensee are not fulfilling these requirements, then you just have to call the relevant department and mention who is your employer. They will do the rest for you. So for example, it's very easy, call EPF, then they will check your records and they will call the employer and they will send a requirement to the employer to fulfill, okay, pay, back pay, plus also they will ask them to pay a fine and on top of it, pay the interest that is overdue on the previous contributions that were held back. Same thing, all the authorities will do the same.
All right, thank you so much, Ms. Rajesh. All right, moving on to the first question from Dr. Huang. Are there any specific agreement, document, or contract between the locum doctors and clinic if the clinic is getting locum services?
The contract is for the clinic to prepare and have, okay. So the contract can be, it can be a locum services agreement. But a locum services agreement, is it an employment contract, will be the subject of debate here. Because if you have the same locum doctor that you use, say, every week on Mondays and Wednesdays for fixed hours, year in, year out, after some time, there may be even an employment relationship that is born from that. And if it is an employment relationship, let's say if the locum doctor is someone who's employed elsewhere and he's only doing part-time with you, that is fine because there may not be a dispute there because the employee, he is already employed. But if he has no other employment, it's only a locum and that is his sole job. And if you decide not to continue with the locum arrangement, he might say, I've been unjustly dismissed. So that it opens up the argument there. So you have to make contracts, yes, you have to provide, okay, whatever paperwork there is. But at the same time, you have to make sure that if it is an independent contractor, that he is there to provide specialist services or visitation, for example, certain number of hours, all these must be transparently stated so that there is no miscommunication and there is no unfair claims being made by either party against one another.
All right, thank you, Dr. Huang. I hope it was clear. Moving on to the next question, also by Dr. Huang. In regards to the maximum working hours for staff, right? So in the event of a staff shortage, for example, a clinic staff is on sick leave and another staff is came forward to help and do an overtime, for example, here stated, I think about 13 hours a day. will this exceed the maximum 10 hours per law?
Well, if the staff is asked to work more than 10 hours, if it's an emergency situation, then it can be where there's a special provision for an emergency situation. But it cannot become a practice. And if it is repeated and it becomes a regular feature, then it is a breach of the Employment Act. For sure, the employee has every right to complain. Many a times, breaches of Employment Act will come to light because the employees themselves, they're dissatisfied, they can go and file a complaint. They can file a complaint whilst they're still in employment, or they can go and file a complaint after leaving the service from the employer, and they can go and ask for backdated charges, etc. So this will be complicated because how do you disapprove, you see? So the JTK will side the employee more often than not in that situation. Or it could be a situation where the employees don't lodge a complaint, but the JTK itself makes an audit, a surprise visit. If they make an audit, of your papers and your documentation and find that there are gaps like this, then you are also subject, to summons and fines and so on. And it can even lead to prosecution, which is even messier than when your employee complains.
So in conclusion, it can be done when it's a true emergency, but not a practice.
Yes, that's right.
Okay, moving on to the next question by Dr. Manohar. For first year of employment, are the employees entitled for annual leave?
Yes, they are.
Yes, they
But
are.
the annual leave, the Employment Act actually says this. It says that you can only take it in the following year. So the first year's annual leave is deposited into your account and you are entitled under the Act to take it in the following year. But quite often what happens in Malaysian context is we allow it, on prorated basis. So meaning if you are eligible for, say, 14 days of annual leave in your first year, the employer will see if you have served 6 months, they will allow you to take up to 7 days, for example. That's a common practice in Malaysia. So it's not illegal to tell the employee who's in first year of service that you can't take annual leave until the second year. That means after 12 months, in the 13th month, you can start taking annual leave. That's not illegal. That's within the Act.
All right, Ms. Rajesh, moving on to the next question, again from Dr. Huang. May I know the related documents application for wages payment in cash method? Are there any website or link available?
Yes, doctors, you can go to the JTK website, which is quite extensive. You can just click JTK. Jabatan Tenaga Kerja, they have a good website, and under there you search for the forms. There are approvals for payment in cash and check, and you can make the application online. Then justifications, the forms are quite comprehensive. You can apply and give proper reasons, and if the JTK is sufficiently satisfied with your reasons, it might allow you to make the payment in the methods that you want to pay instead of online banking.
All right, thank you, Ms. Rajesh. Next is by Dr. Mazida. Hi, what if employment had called for due inquiry, but the employee did not attend? Can employer proceed with the punishment?
If the employee did not come the first time, my suggestion is don't straight away punish the employee. Maybe we do not know. There could be a reason. Postpone the inquiry to one more occasion. If again, in the second time too, the employee doesn't turn up, then you can conclude that the employee has no answer to the allegations and that's why they're not turning up. But remember, the employee who doesn't turn up for inquiry is still your employee. So surely he or she is coming to work, isn't it? Unless they remain on suspension. And if they remain on suspension, meaning you are still paying the salary, right? So I'm not sure how in this case the employee is not turning up. Unless you have suspended the employee or the employee has gone AWOL, absent without leave. So you have to really see the situation. If the employee is still an employee and refuses to turn up for new inquiry, that it's an act of insubordination. That is a further misconduct being committed by the employee. But if the employee has gone AWOL, absence without leave, or has just gone missing in action, if they don't turn up, then you need to document the absence and say that we have given you sufficient opportunity to turn up, to attend the inquiry. Your continuous failure to do so basically tantamount to an admission, and we will proceed to take disciplinary action. You will not be faulted so long you have such a clear paper trail.
Ms. Rajesh, just to add on to that question, I was just thinking, is there like a minimum duration or a waiting period in which we should wait for an employee to show up before taking action?
Well, if you have not suspended the employee, they are still coming to work, right? Okay, then you can, first day, say Monday morning, you ask them to come in for the inquiry, they didn't come, you can shift it to afternoon, you can shift it to Tuesday. But if, let's say, the employee is on suspension, is not coming to work, okay, because the act allows you to put someone on half pay, suspension on half pay, or on full pay, depending on what the contract or handbook or your employment agreement says. So if the employee is away from work, you have the inquiry on one day, then you can telephone the employee and say, I've postponed it to maybe the day after. You still have to come. So it can be close. You need not wait like 1 week in between and all that. It's too long, in my opinion.
Okay, thank you. Next question by Dr. Manohar again. If 3 warning letters have been given and the employee makes another mistake, can we terminate, or do we need to conduct a domestic inquiry?
You still have to hold a due inquiry.
Right, and if an inquiry is conducted, who must be in the board?
Okay, the inquiry panel can be someone who is not a complainant. So if doctor, you are the complainant, you can't sit in the panel, okay? The panel member has to be a neutral person. It need not be 3 people. It can be 2 doctors or 2 senior nurses, someone senior, equal in rank to the employee or more senior than the employee. It can be 1 panel member, 2 panel members, or 3 panel members. But the one who's making the complaint, the accuser, cannot sit in the panel. Then the inquiry becomes negated or cancelled as it becomes biased or deemed biased.
All right, next question here for by Dr. Huang, sorry. For employees beyond 60 years of age and who wish to continue to work in a clinic, what sort of employment agreement are acceptable? For example, is it by contract basis or full employment, etc.? And will they also enjoy similar benefits as full-time workers?
The
Employees.
benefits will be different. I propose that you give different benefits, different terms and conditions, because if you have a continued employment on same terms and conditions, that is the strongest evidence that they never were retired. Okay. I'll also propose and suggest that you have a separate contract with them. The contract can be for a duration that you require a replacement. So maybe the person is actually an X-ray technician, for example, and you can't find a replacement. You possibly need training, okay, to train someone else. So it may be a contract for 2 years. Okay, it can be even for a contract of 3 years. It can be a contract for 1 year. Okay, but if you continuously renew it, that's when the problem starts. Okay, so the person is 61, you give them a 2-year contract, and then you keep renewing the contract until 70. At 70, you suddenly decide, okay, I don't want to keep this person anymore. That employee can say, well, I'm permanent. You never told me that I have to go at certain age. You still need me. Why do you let me go now? So generally, post-retirement employment has to be on a fixed term, but it has to be also for a particular purpose. And as long as the purpose is understood by both sides, and one thing to do is ask the employee to apply for renewal. You do not do the renewal all by yourself without the employee asking, because that also establishes that it is a permanent employment.
All right, thank you, Ms. Rajesh. Next question from Dr. Manohar. Why the Labour Ministry does not act on hospital house officers who are subjected to 36 hours without overtime, and their basic salary is around 2,999 ringgit.
Okay. They come under government contracts or government servants. Government servants are taken out from the Employment Act and Industrial Relations Act. So they can't file constructive dismissal claim. They can't go to JTK and file a Section 20 claim. Hence, if at all, they can only protest, okay, to the health minister. So they are actually in a different kettle of fish, because the law, whatever laws that I'm talking about here only applies to private sector. So I hope Dr. Manohar, you got the answer there. Okay.
All right. Next question from Dr. Mazida. Is it necessary to draw up an employment contract for locum doctors who come to work only upon request? For instance, come on duty only once a week with no regular schedule.
You still have to have a sort of agreement with them because you're having them online. Maybe you can have the agreement as a casual, okay, or visiting doctor or visiting, okay, a medical expert or specialist. You can say that you are here only for 1 week, okay, or once a week and 2 hours per week. It's better to have it in writing and than to have nothing in writing, because later this can be open to argument, isn't it? Dispute. So you are paid on hourly basis during the hours of visit, okay, and this is the maximum hours you'll perform during your visit. These are your requirements, your duties, etc. So at least you have something where both parties, okay, have a clear understanding that where the line is drawn.
Right. Okay. Moving on, we have another question from Dr. Aruna. Quite a long question. I'll just combine. She've asked question twice here. So, hi, I'm Dr. Aruna. I'm currently working as a person in charge at a private clinic, but in my contract, my position was stated as a PIC/resident, even though I was interviewed for the position of a PIC. My APC was used to apply for the Borang B, and I just found out that the salary given to the PIC and resident is the same amount, I believe accumulated same amount. So is this legally acceptable?
Okay, so the question is the salary for PIC and salary for resident is the same amount? Is it acceptable? That means there's one salary for the two functions. Is that the question?
From what I understand, yes, Ms. Rajesh.
That means there's no additional payment to be the PIC. Okay?
Yes.
It depends on what was discussed and negotiated. So if the doctor is unhappy, the doctor can raise it up, or they can say, no, you have to pay me additional payment. This is how, by negotiation and clarity, like what I said just now, is we Malaysians generally are shy to negotiate and discuss and put things in writing. But trust me that, whatever said in words can be forgotten. Over time, people have fading memories. What is in writing often is the safeguard that you have. So if you feel that you have been shortchanged, then you should actually require these things are placed in writing, reopen the negotiations and have it clarified. And if you're not happy with the contract after it's clarified, you always know where the exit door is.
Right, Ms. Rajesh, Dr. Aruna has part 2 of her question. She says that her EPF, EIS, and SOCSO is been deducted from the total salary and OT, not only from the basic pay. Is this acceptable?
The EPF, okay, and SOCSO comes on basic salary, but EPF is also on overtime, just like taxation. Income tax also is payable on overtime, okay? But what is illegal is if the employer takes away his portion from your salary, that is top up. But your portion can be deducted from your total income. If you're not sure, you just look at the formula that is, okay, published in all these websites, and then you can do your own computation. If you still think you have been shortchanged, you can ring up the relevant authority and say, this is my deduction, or you can visit the office and ask them to verify the deductions, whether it's proper or improper. You can challenge your employers. Yeah, you can challenge. But if the employer takes away his deduction, his contributions from your salary, then something is very wrong.
Yes, honestly, I've experienced that myself, Ms. Rajesh, many years ago. So I think doctors, we should also start, make sure to check our monthly EPF contribution and where it comes from and all that.
Yes. So you can visit, okay, you can actually go to, you can take your pay slips and go to any EPF office near to your clinics or where your working places are and ask the officer at the counter to verify and check and tell you whether your contributions look all right or not. And they will do it very fast for you. And if something is wrong, you can also highlight it to them. They will immediately take action. These agencies are really good. Actually, in Malaysia, all the agencies relating to workers' rights, employment, they work very well and they're quite efficient. Okay, and I can say that confidently.
Yep, I agree with Ms. Rajesh. My issue was also solved almost instantaneously. Next question, we have 3 more questions to go, Ms. Rajesh. So the next
there are
question
some questions in the chat also. I see in the chat there's some questions.
Chat.
Okay. One question is Dr. Kali Chandran, I think his full name. Okay, hi, regarding 45 hours per week, is it included lunch break or together? If we work more than 45 hours, what is the next step? Okay, 45 hours is excluding lunch break, okay? And if you work more than 45 hours, you can demand, okay, overtime if it is provided for in your contract. Okay, if it is not provided for because your salary is more than 4,000 ringgit, for example, and I don't think doctors are classified as manual workers, although you use your hands to work. Hence, you can say you don't want to perform the overtime. No one can force you to work in addition to 45 hours a week.
I just noticed there are actually questions in the chat box as well. Right. Okay. Doctors, just to inform everyone, if any of your questions have not been answered by the end of the session, I would share my email address down in the chat box and you could just email your questions to me and I'll forward them to Ms. Rajesh to be answered.
Okay, there are 2 questions that I can quickly answer from the chat box. Dr. Ng Kok Rui says, what is the most common mistake when constructing a contract between employers and employees? It depends on whether you are an employer or asking this question or employee asking the question, Dr. Ng. My answer will differ according to which side you are sending, okay? But I think the most common mistake for employees will be not, okay, clarifying how the pay salary is structured. And for instance, if they work overtime, additional hours, public holidays, and all this, considering that you are not considered as a manual worker and your salary is likely to be more than 4,000, how will you be paid for the additional work? And is there, a share in the income and all these things? So basically, the package, okay, is not clarified here from employee side. From employer side, the common mistake is not demanding or not accurately informing the employee what exactly is the work that you want the employee to perform and not having this stated, because many clinics I see or many private medical health facilities don't provide job description to the employees. So this is left to imagination sometimes. Then you later say the employee failed to do that or this, but there's nothing to prove the employee has failed, okay? And one question from Dr. Jian Sheng Lao or Lao Jian Sheng. Can a businessman, not a doctor, and not doing any clinical work qualify as a PIC? The Act says you cannot. The Act says the PIC must be a qualified doctor. Okay. Any other questions, Dr. Renu? I can't hear you, doctor. Are you muted?
Okay, yes, I was. So this is the question from Dr. Sivandan. If a new employee on probation works for 7 days and then stops working without a notice, and he comes a week later to ask for the due salary, should we pay for the 1 week worked?
Okay, that will be the indemnity that I explained. If the employee has abandoned without paying proper notice, okay, without giving proper notice, you don't have to pay the 7 days. You say, yes, I have paid you the 7 days, but I'm also entitled to deduct it from the notice you have to give me. So you actually you owe me more than I owe you. So now you pay up the balance. Okay, the employee will run away. He will not stand there.
All right, thank you. Next is by Dr. Kali Chandran regarding the 45-hour.
I think I've answered that question.
Oh,
I
sorry.
think I did just
Okay.
now. I think the question I have in the chat box that I have not answered is Dr. Mailita Ramakrishnan, I think. For
All
example,
right.
a doctor is offered a starting basic salary of 8,500 per month for the first year of employment. After the 13th month, this is converted to a 35% deduction from commission based on sales generated. Additionally, there will be no statutory contributions after 1 year. Is it legally permissible to change employment terms in this manner? Answer is no. This is illegal. This is breach of contract. And this is typically how constructive dismissal happens. So you ask the employer to put back, okay, the original terms. And this is also a breach of the EPF Act, SOXO Act, okay, and all the acts that we discussed this evening. You want to change anything in employment contract, both parties must agree. Both must consent. Just because the employer woke up and felt that he likes changing or modifying or doing a variation, the employee need not agree. Okay. So consent is required for any change or in the terms of agreed terms of employment contract.
All right, Ms. Rajesh, did you have you answered this question from Dr. Vanisha about ungazetted public holidays?
Dr. Vanisha, is it?
Okay, let me just read that.
Yeah.
If an employee has resigned, how long can we hold the salary for? The reason being to check for unmatched accounts, missing items related to that employee. And if it's an ungazetted public holiday, are we open on how much the employee salary to be, as in double or the usual salary?
Okay, first question, if the employee has resigned, how long can we hold the salary for? As I said, the salary payment is due by 7th of the following month. Okay, so whatever computation that you want to do, you have to make the payment by the 7th, unless, as I said just now, the employee owes you more than you owe the employee. Okay, then that too, you have to account for it and tell the employee, okay, this is your pay slip, but you have negative pay. Okay, that is what you need to do. Now, ungazetted public holiday, if it's an ungazetted public holiday, question is it a recognized public holiday or not? Because some public holidays may be ungazetted, okay, it's not within the 5 days, but it is there given. Like, for example, recently government, through the Hari Raya, gave additional leave, remember? So that is something that's probably not in the contract. But if you recognize it as a public holiday, then you have to pay the salary. Whether it is double or usual depends on whether the employee worked normal hours or more than normal hours. Okay. The formula is under section 6. The relevant sections are go and look at section 60s. Okay. The series of section 60s in Employment Act. You can find the answers there. It's quite straightforward. Okay.
All right. Ms. Rajesh, can we accept one last question from the
Yes,
Q&A
sure.
box? All right.
Okay.
So it's by Dr. Weng Jun Chiu. Hi, Ms. Rajeswari. During the probation period, if an employee decides not to continue employment and chooses to terminate the contract earlier, does this constitute a breach of contract requiring payment of full indemnity and or compensation as stated in the agreement?
Is this question in the chat box, Dr. Renu?
It's in the Q&A box, Ms. Rajesh.
Q&A box. Okay. Can you repeat the question again for me?
Sure.
Yeah.
Hi, Ms. Rajeswari. During the probation period, if an employee decides not to continue employment and chooses to terminate the contract earlier, does this constitute a breach of contract requiring payment of full indemnity and compensation as stated in the agreement?
Okay, if the employee leaves, okay, does not want to serve, okay, the employee has to give the notice that is agreed by the parties. So let's say if the employee on probation has to give 1 month notice, then he has to pay the 1 month salary in lieu of notice, or actually physically serve the 1 month notice. If not, the employer can claim that from the employee.
All right, all questions have been answered. Thank you, Ms. Rajesh. Dr. Sri, back to you.
Thank you, Ms. Rajesh, for the very wonderful presentation. And not forgetting Dr. Renuka for taking all the effort to organize this webinar. Last but not least, thank you so much for all the participants for taking effort. I understand it is on a Monday night and after a long weekend, but all of you stayed together for almost 40 minutes to hear a very insightful presentation by Ms. Rajesh on the employment contracts, rights, and responsibilities in private practice. Thank you very much, and back to you, Dr. Renuka.
Thank you so much, Dr. Sri. It is my greatest pleasure to express our sincere appreciation to our distinguished speaker, Ms. Rajeswari, for enlightening us on this session today. So in a field as demanding and as dynamic as healthcare, particularly in private practice, it's crucial for doctors not to only excel clinically, but also to be very much aware of all their employment rights and responsibilities. Thank you, Dr. Sri, for joining us today. Thank you, Ms. Rajeswari, for spending time to enlighten all of us. And on behalf of PPS MMA and JDN, thank you, everyone. I hope I'm able to organize another session on this topic in the soonest. Until then, good night and take care.
Okay, good night, everyone. Thank you.
Thank you.